Steve Dulan of the MCRGO wishes to speak briefly in support.
Thank you, Senator. Thank you, members of the committee. In addition to being a member of the board of the Michigan Coalition for Responsible Gun Owners, I'm also an adjunct professor at Cooley Law School. I've been teaching a class for years called Gun Control Seminar, and we've had a lot of discussion in our classrooms for years about the Firearms Freedom Acts that have been in place in other states. The thing that's not been discussed so far, the idea is that we're not only supporting the Second Amendment at the United States level, we're supporting Article 1, Section 6 of the Michigan Constitution, which is our right to keep and bear arms. This type of law, and specifically this bill, is an important assertion of state sovereignty. The three branches of government are not legislative, judicial, and executive. The three branches of government are the people, the states, and the federal government. The state of Michigan is not a department of the United States. It's not a subdivision of the United States. The United States is a creature that was created by the states. The state of Michigan has the sovereignty and the police power to legislate for the health, safety, welfare, and morals of the community. The federal government only has those powers which have been delegated to it by the states. So the Supremacy Clause argument actually probably fails, in my opinion, and in the opinion of several other commentators. In addition to myself and MCRGO, I'm sure that we'll have the Cato Institute and the Goldwater Institute on our side of this when we do get to court, and I think it probably will go to court, Senator. Certainly the Montana bill is in the Ninth Circuit right now. We're in a different federal circuit. The ruling that happens over in the Ninth Circuit doesn't have controlling effect on us, so even if the Montana bill is struck down in the Ninth Circuit, this bill could survive in the Sixth Circuit. This is an important assertion of state sovereignty, I think, is the best way to look at the Firearms Freedom Act.
Thank you very much. Do we have any questions? Senator Shoemaker.
Thank you very much. I certainly support the intent of this, but I am, like Senator Beda, very concerned that it doesn't pass constitutional muster as it pertains to the Interstate Commerce Clause. And I go back to that case that I'm sure you're very familiar with and could probably cite the name off with the truck axles, where I think it was like Iowa or Nebraska, where they regulated truck axles and more or less got rid of the intrastate commerce clause and regulated that every good out there is with regards in interstate commerce. And so I just worry that I don't want to pass anything that won't hold up constitutionally. And so if you can comment to that.
Sure. Yeah, it actually started with a case called Wickard v. Filburn back in the 40s, which was a strange case of a farmer feeding his own grain to his own cattle. And the federal government asserted a right to regulate. It got up to the U.S. Supreme Court. This was post-FDR's court packing threat, and it passed 9-0. In the opinion of many commentators, that case was decided wrongly. And these Firearms Freedom Acts actually might be the beginning of overruling this idea of the cumulative effect argument, which also came into play in the truck case. I agree with Senator Jones. There are many things that have been accepted law in the past that were actually wrong. And in my personal opinion, this idea that the Interstate Commerce Clause should be treated as a federal police power is inherently wrong and ultra vires. The federal government does many things that go far beyond the text of the Constitution, including regulating firearms. However, the states are on strongest ground when they're legislating along with the U.S. Constitution. So I think we're stronger here than we would be, say, attacking directly the truck axles or the grain issues, because we've got the Second Amendment and we've got the Heller case and the McDonald case. The Heller case several years ago at the U.S. Supreme Court asserted that the Second Amendment protects an individual right, including self-defense. And then the McDonald case said that the Second Amendment applies via the 14th Amendment to the states. And so all we're doing with this is not, well, this shouldn't be all we're doing. In addition to asserting state sovereignty, this bill would also be in support of the U.S. Supreme Court's interpretation of the Second and 14th Amendments. So I feel like this is a very strong constitutional argument. And these aren't ideas that originate with me by any means. I've been reading briefs from Cato, Goldwater, other well-respected and well-researched briefs. Absolutely.
Thank you very much.
Thank you.
Senator Beda has a question.
Oh, yes.
Yeah, thank you. And you know, I can kind of get an idea where you're coming from on this, but I'm still taken away from this. It's going to be in court. taxpayers are going to be paying for a lawsuit, and there's still questions out there that even though you might feel confident on it, and as attorney, oftentimes you feel comfortable going into court on it, there's a big question there. And that was what first popped out at me, and I really do have some concerns about those two sections that I referred to, and I think it is going to be a problem, and I think it's going to cost the taxpayers of the state some money on it. And I'm just kind of wondering, even if timeliness, if we didn't take this up now, because the federal regulations or laws aren't even out there yet. So we're reacting to something, the sponsor is reacting to something that's not there yet. And it just seems like we're buying a lawsuit without knowing what we're buying a lawsuit for. And that's a little problematic to me on that. As an attorney, I know you look at both sides of it, and I appreciate your legal analysis of it. Tell us the other side of it. Let's play moot court. You're a law professor. You've had to do this in law school. What's the flip side of it? How does this fail?
Well, the way it could possibly fail, and the arguments that have been made in the Montana case that's in the Ninth Circuit, really boil down to exactly what you said, Senator, which is the Commerce Clause. There is a fair amount of jurisprudence regarding the Commerce Clause. It's been treated and accepted by many of the circuits, and in some cases by the U.S. Supreme Court, as essentially a federal police power. My opinion, that's a misreading of the Constitution. It is controversial. This is by no means well settled. And we shouldn't assume that we're necessarily going to go to court. I feel like we probably will. I think you and I agree on that this will end up in the federal courts. But the Montana case is way ahead of us. Montana got way ahead of us, and the Firearms Freedom Act in Montana may prevail at the Ninth Circuit. Those of us who watch the Ninth Circuit have learned not to predict what the Ninth Circuit might do. So it's possible that this bill would not be challenged in the federal courts, in the sense that the Sixth Circuit might look at the Ninth Circuit and say, we're going to be persuaded. It probably will, though. It's an important assertion of state sovereignty, though. Just because there might be a fight doesn't mean that we shouldn't proceed, because the states at this point in history are being treated more or less by the federal government as, if not completely inconsequential, at least as largely irrelevant to what the federal government wants to do. And that's not the original structure the framers put in place. That's not consistent with the idea of federalism and state sovereignty. And this is a better place to challenge that idea and assert our rights as Michigan citizens and as a state than many other places, because of the fact that it's consistent with Second Amendment.
Okay, do you have a brief follow-up question?
Yeah, I mean, that's been a common thread, argument over the years. Groups, for example, proposing civil rights legislation in the South made the same argument, and we've seen that throughout history with the relationship between the feds and the state. Again, I'm just not wanting to buy a lawsuit, and I do have some major concerns about the constitutionality of it as it's dressed right now. But I do appreciate the analysis and love to get your card afterwards, because it sounds like you have some real interesting background here, and I'd love to talk to you some more on that. While I've got the mic, if I can ask if the LSB has, somebody from LSB may have proposed or put together a memorandum on the constitutionality of that. That might be useful for the committee to look at. Thank you.
Okay, we'd ask if the Legislative Service Bureau has further information available. Okay, he will get with you afterwards. Doesn't have it available here at the committee. All right. Senator Shoemaker, do you have a question?
Yeah, just a follow-up question. When it comes to interstate commerce, and I apologize that I'm hung up on this, but I think attorneys are trained a certain way in law school, and it's hard to go against that. Like the components that make, like it says for Michigan made, well, is it down to like the iron that is made the gun? I mean, how is it diluted to made in Michigan?
I believe the language is firearm part, or firearm accessory, if I remember correctly. And the current definition of firearm for both state and federal purposes is actually a completed receiver. That is the part that holds the trigger group together, typically in most guns. So it wouldn't include raw steel. It wouldn't even include partially machined receivers under the current law.
Do you also have a white paper you could share with me on just in case I get asked about the constitutionality of this, that you could share with this committee?
I can. In fact, I think the Cato brief in the Montana case, it serves.
Okay.
It's actually fairly short. and I think that would be a great starting point.
Okay.
Thank you very much.
Thank you.